Well, good morning. I'm Greg Monroe from the faculty at the University of Montana School of Law. It's my privilege to welcome you this morning to this formal session of the Montana Supreme Court. The court travels around the state on occasion. They come here to Missoula every year, and we're blessed to have them. So this morning, this will be the chambers of the Supreme Court as they hear arguments. Because this is a formal session, I would ask you at this time to remove any hats. I especially want to welcome any of you who are for the first time seeing the Montana Supreme Court. All of you are part of a distinct and honored minority of people who've been privileged to sit in a session of the court. It's a chance for us this morning to understand more about the judicial system and the role of judges and lawyers in society. We'll begin this session with overviews of the cases. There are two of them this morning in the court system. The most important theme that I want to touch on this morning as we start is that society depends on an independent judiciary. And the judiciary, as you recall, acts as a check on the legislative and administrative branches. It's part of our checks and balances in society. The two cases this morning illustrate that very well. The first case you're going to hear is Caldwell versus Maco Workers' Compensation Trust. That's the Montana Association of Counties Workers' Compensation Trust. For our purposes this morning, you can kind of consider it like an insurance company. That case is about the Montana Supreme Court acting as a check on the legislature. They're reviewing what the legislature has done to see if it's constitutional. The second case is Kalispell Education Association versus the Board of Trustees, Kalispell High School District Number 5. And that case involves a teacher's rights and the termination of a teacher in the Kalispell School District. And you will see as an example of this court's check on the activity of the administrative branch, in this case, the school board. This morning, I'm going to talk about Caldwell versus Maco Workers' Compensation Trust, and I'll talk a little bit about the workers' compensation system, workers' compensation law and introduce you to that and the workers' compensation court. When I'm done, Professor Bill Corbett's going to talk with you about the Kalispell Education Association case. After that, the court will go in session for approximately an hour on each of these two cases, and you will, at the end of the morning, have seen two Montana Supreme Court arguments. Let me talk about Caldwell versus Maco Workers' Compensation Trust first. And let me start by telling you a little bit about the facts of the case. Harold Caldwell, who happens to be here this morning, he's sitting down here in front, he started his first career in the military, and he retired from the military at a young age as an E9, which is a very high rank. And he was a hard worker. He continued to work full-time in the workforce. And when he was 62, he began collecting Social Security retirement, as we who have reached 62 can do if we choose. But he continued to work because that's kind of his lifestyle, and he worked full-time. When he was 77 years old, he was the manager of the Ravalli County Airport and had an unfortunate accident at that time. He slipped on ice on either a concrete or a paved apron there, fell, hit his head very hard, suffered subdural hematomas, and had a very severe head injury. He recovered from that through medical treatment, but he could not return to the job because he had some deficits and he needed rehabilitation. He applied for rehabilitation benefits and he was refused. He was refused because there's a statute in Montana that was passed by the legislative branch that says they don't have to provide, and the benefits for rehabilitation under the work comp system are excluded if the person is eligible for retirement benefits. And Mr. Caldwell was eligible and was receiving retirement benefits even though he was working full-time. Mr. Caldwell challenged that statute. He challenged it under the Montana Constitution. He said that the Constitution guarantees each of us equal protection of the law, and that this was a denial of equal protection because he was being refused rehabilitation to return to the workforce that a younger worker would not have been refused. He filed the case in the Workers' Compensation Court. I'm going to talk about that more in a few minutes. The Workers' Compensation Court heard the case, reviewed the briefs, heard the arguments, and ruled that the statute was indeed unconstitutional. And they held that it was a denial of equal protection because it denied Caldwell a benefit that a younger person wanting to re-enter the workforce would be entitled to. Maco, I'm going to call the Montana Association of Counties Workers' Compensation Trust, Maco, appealed that to the Montana Supreme Court, and that's how the issue is here today. And so that's the argument you're going to hear today. The issue, and the sole issue in front of the court in this case, is whether that statute refusing rehabilitation benefits for persons receiving Social Security retirement benefits denies Caldwell equal protection under the Constitution. Let me take a sidestep now for a moment, for I know that we have some high school students and other students who may not be thoroughly familiar with some of this. So let me just talk quickly about court systems that you'll see in Montana. We have in Montana at least three separate court systems. One is the federal court system, another is the state courts, and the third is the tribal courts. Let's talk about federal courts first. And by the way, this is a state court case, but let me tell you about federal courts. Federal courts are those courts that have been set up by the United States Constitution and by Congress and by the United States Supreme Court. Those courts have basically two kinds of cases they deal with. One is disputes between citizens of different states. Or between different states. If Montana sues Wyoming over a water compact, that can be heard in federal court. If you have a dispute with an insurance company located in Massachusetts, you can file that in federal court and have it heard here. The second kind of case, the federal courts here, are what are called, and the first one, by the way, is called diversity. The second are federal question cases. And so if the issue arises under the United States Constitution or under federal legislation or federal rules, a federal question can be raised and you can bring that to the court. Here's a good example that we see in Montana all the time. Wolf delisting, which is in the papers all the time, that arises under the Federal Endangered Species Act, which Congress passed, and consequently that's why you see all those cases in the federal court here, and you see Judge Malloy, the federal judge in Missoula, making those decisions. Now, the tribal courts, many of us tend to forget that in Montana we have 7 tribal reservations, and those are by law like 7 separate sovereign independent nations. They have their own court systems, they have their own systems of rules. And the state courts, which are the ones that probably touch your lives more than any others, there's a system of those courts in Montana. The state district courts, and one of those state district courts is the one in the county courthouse downtown. Those state district courts are what's called courts of general jurisdiction. They can hear anything. So they do divorces, they can do murder cases, they can do debt actions, they can do all the criminal hearings, insanity hearings, guardianships, virtually anything that comes up. We also have courts of limited jurisdiction. Many of you have probably had contact with the justice courts in Montana. Justice courts have a civil jurisdiction of $7,500. That's the limit on what they can handle. And they can hear misdemeanor cases, and they can do preliminary work on felony cases, but you don't try felony cases in a justice court. So it's called a court of limited jurisdiction. So are the municipal courts. The municipal courts can hear DUIs, they can hear misdemeanors, and they have certain jurisdictions that have been limited by the legislature. Now, there are 2 other courts in Montana that have very specific jurisdictions. One of them, they're courts of limited jurisdiction. One is the water court, and that court is what determines the water rights on the farms and ranches and the cities and all those kinds of things. The other is the workers' compensation court. Workers' compensation court hears issues arising and cases arising from workplace injuries, and that's all that court does. So what is workers' compensation? We hear that, and many of us aren't clear on what that is. So let me tell you a little bit about workers' compensation. In the early part of the 20th century, the Industrial Revolution was in full bloom, and the classic example of that is the city of Butte. Butte was a heavily industrialized town with all the mining and smelting going on and all kinds of other operations. Back at that time, unfortunately, we simply didn't have the workplace safety that we have today. There was no OSHA, and the fact is, thousands of workers were maimed or killed on the job. And the legislatures decided that it was not going to be a workable system to allow workers to sue their employers for all those injuries and deaths. And so they worked up the workers' compensation system, and here's how it works. And we call this the quid pro quo. Workers gave up their rights to sue their employers in the state district courts. And in return, if they were hurt on the job, even if it was their fault, this is a no-fault system, they could recover their medical expense in full, and they could recover a certain percentage of their lost wages. So the system was designed to make sure that they were taken care of with medical expense and lost wages. And in later years, they put in rehabilitation benefits. They gave up the right to sue for pain and suffering, punitive damages, or any other compensatory damages. That's called the quid pro quo. And they also gave up, we call it the exclusive remedy. Their exclusive remedy is to go to the work comp court. So in Montana, we have a workers' compensation court. It's a single court. It sits in Helena. The judge is Judge Jim Shea, and he is the one who heard this case initially. Caldwell's position in this case, as I said, is that this statute violates the Montana Constitution's Equal Protection Clause in that it treats retirement age workers differently than younger workers. The Montana Association of Counties' position is that the statute is actually constitutional because it is rationally related to a legitimate government objective, and that is to be able to fund and maintain this workers' compensation system. As I said, Maco appealed this case to the Montana Supreme Court, and I haven't talked about the Montana Supreme Court. In our state judicial system now, the Montana Supreme Court is the highest court. It's the court of last resort. So all those district courts can appeal cases up there. The parties to cases in district courts can appeal there. The parties to the workers' compensation court can appeal there. The parties to the water court can appeal there. And so that is how the case comes to you today, and what you're going to be watching is the case involving this issue. Now, let me touch on one other thing, and that is that the case that's come up here, when it was filed at the work comp court, we usually think of lawsuits as involving money. But this case doesn't involve any money. You won't hear the attorneys talking about the money aspect or damages, that kind of thing. What they're going to be talking about, what was asked for here, is called a declaratory judgment. One of the things that courts do very commonly is citizens can ask them to declare what the law is in a dispute. I'll give you an example. If you had a subdivision that had covenants or restrictions that said no mobile homes, and somebody put in a foundation and then they brought in a manufactured home in two halves on wheels and took them off the wheels and set those two halves together and made a house in the subdivision, and they were sued because the subdivision residents claimed that was a mobile home, when they sued, they would ask the court to declare whether that is a mobile home within the meaning of those subdivision restrictions. So that's one of the things our courts do. In this case, Mr. Caldwell asked the workers' compensation court to declare that that statute excluding him from rehabilitation benefits is unconstitutional under the Montana Constitution. And that's the relief that's today what's being asked. Judge Shea at the Workers' Compensation Court did issue that declaration. That's been appealed. So what's being done today, the party that brought this action to the Montana Supreme Court is Maco, and Maco is asking the court today to declare that that statute is constitutional. And you'll hear the arguments on both sides. So what happened here is the attorneys filed the action, the appeal, and then they filed what's called the record, any important documents that had to come up, and then they drafted and filed briefs. And those briefs have the facts of the case, which are really undisputed. They have all the case law they're relying on, case precedent. They have the statutes that they're relying on and the constitutional provisions. And you'll hear all of that in the arguments this morning. The attorneys will come up this morning and you will hear two different sets of attorneys arguing, I believe. There are the attorneys for the parties who will argue, and there are also amicus here. And what amicus means is when an organization or party sees that an issue is up before the Montana Supreme Court and feels that it's an issue that affects them too, they can petition the court and ask, may we enter as amicus? Amicus is Latin, meaning friends. Amicus curiae means friends of the court. And so they petition, may we come in as friends of the court, and may we brief this, and sometimes, with permission of the parties, they will be able to argue here also. So you may, on each of these cases, you may see more than one attorney arguing on each side. The arguments will be short. So the sole question that's really in front of you this morning is this statute constitutional? Listen to the arguments, because the court has to test this statute against the Montana Constitution. And so your question might be, well, how do they go about doing that? And listen, and you're going to hear the attorneys arguing for what it is, what level of scrutiny they have to observe, and what makes the statute constitutional versus unconstitutional. So it's a great chance this morning to hear the interplay between the Constitution, the statutes that the legislature passes, and case law. And you'll hear the attorneys here arguing all three of those things this morning. So it's a chance for you to observe the role of the Montana Supreme Court in our system of checks and balances, a chance to observe how they go about testing a statute to see if it's constitutional. And I invite you to listen carefully to these arguments, see what the test is, see whether you agree and disagree, and listen to counsel. And ultimately, when you're done listening to the arguments this morning, ask yourself, if I was the judge, how would I decide this case? It's a great privilege to have you here to see this morning. I thank you for your attendance, and I hope you find the arguments very interesting. Thank you.
Good morning. My name is Bill Corbett. I'm also a law professor at the University of Montana Law School, and it's my job to introduce the second case. Now, my marching orders are this. I introduce the second case, but I have to be off this stage at 10 o'clock because that's when the court comes in. So I'm going to do my best to give you a background in this case, but the last thing I do is get off the stage. The case that I'm going to introduce is the Kalispell Education Association in William Hartford versus the Kalispell School District. In this particular dispute, none of the facts are in dispute. Everybody agrees on what the facts are. It involves solely an interpretation of law, and the court's going to be asked today to interpret the law, the state law, and we're going to talk about what that state statutory law is in a minute, and the terms of a contract. So that's what this case is all about. So I'm going to tell you what the facts are briefly, but you're not going to hear any dispute when the attorneys talk about the facts in terms of what the facts actually are. William Hartford was a tenured teacher with the Kalispell School District. Montana law provides that to teach in a school district, the teacher must have a valid teaching certificate issued by the state. Mr. Hartford had a teaching certificate when he was first employed, and he maintained that certificate until it expired. The reason the certificate expired was that Mr. Hartford failed to take the necessary steps to renew it. There's no skullduggery or anything. He just probably forgot to renew it, and the certificate expired. What we're dealing with in this case are events that occurred in 2008. In May of 2008, the school district offered Mr. Hartford another teaching contract for the next year. 2 months prior to that, his teaching certificate had expired. But neither Mr. Hartford or the school district knew that his teaching certificate had expired. That fall of the school year, Mr. Hartford resumed his teaching duties, his regular teaching duties in the school district. In October of that year, the school district and Mr. Hartford learned that the certificate had expired and that he had been teaching since the start of the school year that fall without a valid certificate. Because under state law, the school district could no longer employ Mr. Hartford as a certified teacher because he didn't have the teaching certificate, they made him a non-certified substitute teacher. He remained in that status until he was discharged in December of 2008. So he starts teaching in the fall without a teaching certificate. It's finally learned that he doesn't have a teaching certificate. They take the certified teaching job away from him, making him a substitute. And then in December, they decide to discharge him because apparently they felt they didn't need him or didn't want him. What makes this case complicated is that the school district has a collectively bargained agreement with the Kalispell Education Association. Now let me just talk about what is a collectively bargained agreement. The Kalispell Education Association is like a union, and it represents teachers in the Kalispell School District. In this instance, the certified teachers. So the certified teachers, through their bargaining representative, the Kalispell Education Association, sit down and bargain a contract for all of the certified teachers. So that's the contract that Mr. Hartford had. It's a collectively bargained contract with the school district. The agreement, that collectively bargained agreement, provides that the district must have just cause to discharge a teacher, and that a discharged teacher may file a grievance with the district alleging lack of just cause. In the event the district does not resolve the grievance in favor of the teacher, the contract provides that the dispute will then be resolved by an arbitrator, a person jointly selected by both the district and the Caldwell Education Association. Well, let's now talk about what an arbitrator is. Well, an arbitrator is a person who is hired by both the district in this case and the Educational Association to come in and hear their dispute and render a decision. So that's what an arbitrator is. The Caldwell Education Association, representing Mr. Hartford, filed a grievance over the discharge, and when the matter was not resolved, the Caldwell Education Association wanted to move the case to arbitration and have an arbitrator come in and resolve the matter. The school district refused to arbitrate. At that point, the Caldwell Education Association went to the district court in Caldwell seeking an order to compel the district to arbitrate. And ultimately, after hearing the matter, the district court agreed with the Caldwell Education Association that the dispute should be resolved by an arbitrator. The decision of the Caldwell District Court is being reviewed today by the Montana Supreme Court. This morning, you're going to hear the attorneys for the school district and the Caldwell Education Association argue this matter. The resolution of this matter really turns on the wording of the collectively bargained agreement and the state law that says if you don't have a teaching certificate, you can't be a certified teacher in Montana. Because for the next few hours this auditorium has in fact become a large courtroom, I need to say a few words about court etiquette. Shortly after my introduction, the justices will enter the court and take their seats immediately behind me. At that point, the audience and myself will be asked to stand, and the court will be called into session. On behalf of the Montana Supreme Court, the Montana Law School, I want to welcome you to this court session today. Thank you for your attendance, and I particularly thank the Montana Supreme Court for taking the time away from its busy schedule in Helena to conduct these hearings outside of Helena, in this instance in Missoula. At this point, I would like to introduce the clerk of the Montana Supreme Court, Ed Smith, and it will be Ed Smith's job then to take the proceeding over. Ed Smith.
All rise and give your attention to the Honorable Justices of the Montana Supreme Court. This court is now in session.
Good morning. I'm Mike McGrath. I'm the Chief Justice of the Montana Supreme Court. With us today on my right is Justice Patricia Cotter, Justice Mike Wheat. On the far left is Justice Jim Rice, and then Justice Brian Morris. Justice Jim Nelson and Justice Beth Baker will participate in this case, but due to long-standing prior family commitments, they were unable to be here for the argument. They will listen to the arguments and watch the arguments online. And as I said, participate in the case. Are counsel ready to proceed? Mr. Grossfield?
May it please the court. My name's Norm Grossfield. I'm an attorney in Helena. I've appeared before the court many times in my 40 years of law practice, and maybe the last time. It's nice to see the turnout in Missoula and the interest that the court system has to the Missoula community. The case before you has been extensively briefed by the parties, and you all know what the issue is, but I want to give a little bit of perspective on this issue. We have an issue here in which Mr. Caldwell was injured while working in Ravalli County, and he was past the age of Social Security retirement. I compliment Mr. Caldwell for his work ethic. I think we are all impressed with his work ethic and his desire to continue in employment. But we have an issue
well, counsel, can I interrupt you then?
Yes.
Because that's the part of the case that troubles me, is that this gentleman wants to work, and he was working in the workforce. He retired from the military. He was drawing Social Security, but he was working full-time when he got hurt, and he wants to continue working. Why should we not treat him like any other worker that wants to return to the workforce?
Your Honor, it becomes, I think, an issue of degree. And I want to address that. The workers' compensation system is totally a statutory system, created totally by the legislature. It started in the early part of this century. It came across from Germany originally. In 1915, the basic structure of the Montana system was established. And it evolves over the years, and it provides different categories of benefits. And there are distinct categories of benefits. And so it's a balancing of the cost in relation to what can be provided to employees and the cost to the system itself. And the legislature has to make those kind of judgments. In this particular case, the legislature made a judgment that those that have reached general retirement age, which is recognized by Congress in relation to Social Security retirement, so it's recognized throughout the United States that generally people are retired at age 62 to 65. And a decision has to be made. It's a balancing test. Do we provide benefits to retrain elderly individuals and take away benefits from those that should be retrained when they're 20, 30, 40, or 50?
But counsel, 3971-1006 already provides a test for whether a person will qualify for rehabilitation, and then that test takes into account age and other factors. Why isn't that test sufficient to meet the criteria that you're worried about, and why wouldn't this be a sufficient fail-safe for any person of a particular age who wants to try to get back into the workforce?
Well, I think that really supports our position, frankly, because the legislature decided that age was a significant issue when it comes to providing at what level, at what age do you provide rehabilitation assistance. So I really think that supports our position and not the other side. Of interest, you know, the system evolves over the years. The 1915 structure of the workers' compensation system is still basically in existence. Of interest, in 1915, medical benefits were provided for the first 2 weeks of an injury, and a maximum of $50. In 1950, I happened to look up the law, the legislature magnanimously increased that to the first 9 months of an injury, and a maximum of $1,000. It wasn't until the early 70s that medical benefits were increased to unlimited benefits for a lifetime. And we're looking at legislation now that is actually going to cut back on that. But the workers' compensation system is an evolving system. And the criteria for the rational basis test that this court has adopted throughout the years on constitutional issues involving workers' compensation matters is a very minimal test.
Counsel, how do you reconcile what you're asking us to do with what the court did in the Reeser case? In that case, as well as this one, we're talking about temporary as opposed to permanent benefits. So how do you reconcile what we said there with what your position is here?
I think the court got it right in Reeser, and I think the court got it right in Satterley. In the Reeser case, the court stated that a person that is 45 or so and a person that's 65 should receive the same permanent partial benefit. But permanent partial benefits are completely distinct from rehabilitation benefits. They're totally separate and distinct benefits. The workers' compensation system sets up basically 6 different types of benefits. And I think the court got it right in Reeser because it stated that the formula that kicks in for wage loss benefits, for an impairment award, etc., for a 65-year-old, they're going to have the same income loss as the 45-year-old. But that's different from rehabilitation benefits. Rehabilitation benefits are a separate benefit. And what happens is if this court affirms this decision, you're going to be having individuals that are in what's generally recognized as a retirement area. You're going to have them retrained. But the practical effect of that in the eyes of the legislature is that removes benefits for the younger individuals that are hurt. It cuts back on wage loss benefits, which are a very important part of the system. So what you're doing is you're going to provide benefits for those that have really, in the eyes generally of the public, and as recognized in Satterley, where this court stated and recognized that, yes, those that have hit the retirement age, and I'll just finish this point, those that have hit the retirement age are generally considered to be retired. So if you're going to extend those benefits, which, by the way, are costly, you're going to force, in the legislature's mind, a reduction in true wage loss benefits for the younger individuals or rehab benefits for younger individuals that should be entitled to that. And then I'm going to now defer to Brad Luck to continue our argument. Thank you.
Mr. Luck.
May it please the court. My name is Brad Luck, appearing on behalf of Amicus Montana State Fund in this action. I would like to thank the court for allowing us to provide our arguments and also thank Mr. Grossfield for sharing his very limited time with us this morning. He granted me 8 minutes. I know from the Walters argument that we had recently that needs to be done efficiently. I learned, and the Chief Justice reminded me, that we needed to get to the point, and I'm going to try to do that today.
Counsel, does the constitutionality of the Montana statutes depend upon the continued viability of Social Security?
I think the constitutional analysis of Section 710 is directly related to the fundamental review of Montana law, of this court's interpretation of constitutional principles, and this court's interpretation specifically of Section 710 as it relates to Satterley and the definitions that are applied in Section 710, and it's not related to the Social Security system because it's definitional and it's entitlement based. And I can explain that by...
So if Congress abolished Social Security or turned it into a voucher system, it would have no effect on the constitutionality of these statutes?
I don't believe it would, Your Honor.
Why is that?
Because I think the test of this statute is the fundamental application of Montana law under the Montana Guarantee of Equal Protection. If we, in order to expedite a discussion of those fundamental principles, I prepared a handout for the court to outline those things, and I wanted to talk about them, and I think that's the answer to the question. And the answer to the question is this statute constitutional under Montana law? It is by virtue of the review process that this court has enunciated in terms of constitutional standards. It is constitutional on the basis of this court's repeated assertion and verification that it defers to the prerogative of the legislature in the relation to the amount, duration, and payment of benefits and workers' compensation. But most specifically, it's constitutional because of the basic tenets that this court considered and applied in the Satterley case, which considered the Montana Constitution, which considered the entitlement and the fundamental basis for justification of the statute.
Satterley was concerned about lifetime benefits. We're talking here about rehabilitation benefits.
Your Honor, I think we need to read these cases in line. Reeser started the process of analyzing Section 710 and indicated that for permanent partial disability benefits, the statute was unconstitutional. After Reeser, we had the decision in Rausch, and we had the decision in Satterley. Satterley indicated and kicked the can way down the road in terms of the approach to an analysis. He said we have to analyze each separate benefit. Each separate benefit that we're talking about here, vocational rehabilitation benefits, in light of the constitutional principles that the legislature has the prerogative to set the manner and method of payment. Most importantly, though, the court said that Section 710 is a definitional statute. Section 710 defines, the legislature defines who is retired, and it was appropriate and it was accepted. This court indicated that the legislature stated in that definition that those people receiving or eligible to receive Social Security in the prerogative of the legislature were defined as being out of the normal labor market, that their work life had ended.
Didn't we pin that, I was just going to say that, on work life? We said the work life of people getting permanent total disability benefits was by definition over because they could not return to the workforce. Mr. Caldwell wants to return to the workforce and would argue that his work life is not over. How do we make that distinction?
Justice Cotter, I think you make a great point. There are equitable considerations and there are perhaps political considerations in relation to arguing on behalf of Mr. Caldwell's position. He worked hard. We respect his work ethic. He's retired military. We respect that service. However, this is an facial challenge to the statute as opposed to an as-applied challenge to the statute. As a result, we need to review the entire scope of the statute in light of these discussions. And I think it's real important to say that if we apply the fundamental constitutional workers' compensation and holding of Satterley to this situation in terms of a facial challenge, it is especially applicable to vocational rehabilitation benefits because this court said in Satterley, in reviewing Section 710, we don't question the fact that this is an appropriate approach, an appropriate definition. And then we apply it, though, to specific benefits. In that case, you applied it to permanent total disability benefits and said, it makes no sense if, by definition, a worker's work life has ended, if, by definition, that we accept from the legislature that they're out of the labor market, to pay them total disability benefits.
But, counsel, that definition depends upon the federal law. The legislature said as long as you're Social Security eligible. What if Congress changes the eligibility age? Does the statute change with it?
I don't know that the court wants to do an advisory opinion in relation to that.
But back to my original question, though, does the constitutionality of the statute hinge on what Congress does with Social Security?
Although I think that's a political question, and I think it's an advisory opinion question, and in relation to Mr. Caldwell and the status of Section 710, I don't think it applies. But in that context...
Could the Montana statute stand if Congress abolished Social Security?
In that context, I think it would probably be challengeable if there was no Social Security system in order to kick in Section 710, because those elderly people that are not on Social Security or eligible for Social Security today are not affected by Section 710. So I think, Your Honor, if that case came up and if that political eventuality occurred, that would be a good point. I don't think it's applicable to this situation, however. Back to the situation in terms of the application of the law and the equities and political issues involved in your question in relation to doesn't he have the right to work? And I think Justice Wheat, you mentioned that. Of course he does. But we've made that definitional, statutory prerogative, definitional determination that those receiving or eligible to Social Security are considered by definition out of the workforce. If you're out of the workforce, it makes no sense. It is not rational to retrain you. Said another way, if you're out of the workforce, it is rational for the legislature, is reasonable for the legislature to exercise its legislative prerogative and determine that we will allocate vocational resources benefits to those individuals who remain with a work life, who remain by definition as a matter of law in the workforce, and not those that are already out.
But counsel, doesn't that create two different classes of workers? You have those workers over 65 who are working at their peril. They have limited rights under workers' compensation, and other workers who have greater rights.
No, I think that this goes to any quid pro quo and exclusivity considerations that the court has, and I know, Justice Morse, you have those considerations and the concerns in these cases. I don't think it does at all. If someone is on Social Security and defined as being out of the workforce, yet they continue to work, they have a lot of protections in the Workers' Compensation Act, as did Mr. Caldwell. The Act applies to them. They get lifetime medical benefits, they get impairment awards, they get temporary total disability benefits. They are only defined out of benefits in relation to Section 710 in relation to specific benefits, permanent total, rehabilitation, and that's it. So although it's not the same, it is the exercise of the legislative prerogative, which this court, in analyzing Section 710, specifically said in Satterley that it was, we can't simply strike Section 710 down because we don't agree with the legislature's policy decisions. That it's rational and reasonable to terminate permanent total disability benefits when by definition as a matter of law someone is defined as being out of the workforce. It is even more rational and just as appropriate to not retrain someone who by definition is outside of the workforce. Justice Nelson said in Kurzich,
Mr.
we
Luck,
all
your
agree.
time has expired.
Pardon me?
Your time has expired.
One final statement. Justice Nelson said in Kurzich, we all agree that workers' compensation claimants need to be fairly compensated. The problem, though, is as we consider that subjective analysis, we have to apply fixed and clear law. The fixed and clear law through Satterley and basic fundamental constitutional analysis and workers' compensation principles indicate that you don't retrain someone who is out of the workforce. Thank you.
Mr. Palmer.
May it please the court, my name is Rex Palmer and I am pleased to represent Harold Caldwell. He's at council table here. I'd like to make two quick points and then move into more of the details. First, reading from paragraph 23 of Reeser. There is no rational basis to deny a class of injured workers a category of benefits based upon their age. And now I'd like to make a brief point by illustration, if you'll just humor me for a moment. In World War II, there was one land battle on U.S. soil in North America. The Japanese had invaded and occupied one of the Aleutian Islands, and in order to remove them, over 500 Americans lost their lives, and that involved hand-to-hand combat. And it also involved the Medal of Honor being awarded to one young 20-year-old private named Joe Martinez. That's a footnote in history books, if anything. But the Attu project, this is Attu Island, involves a monument naming each one of those soldiers and giving a special recognition to Mr. Martinez. That project has now been fully funded. The monuments are constructed. They'll be placed on Attu Island when the final approval is received from the federal authorities. And why am I telling you this? Mr. Caldwell, after his retirement and after his injury, conceived, initiated, and coordinated that entire project after his so-called retirement age. That shows the energy, the vitality, and the competence that older workers can bring into the workforce. They bring experience, they bring wisdom, they shouldn't be written off. Our Constitution, according to Judge Shea, does not allow us to write them off in the way Code Section 710 would write off the opportunity for retraining.
Well, Counsel, in Satterley we said that it was permissible for the legislature to make some assumptions about retirement and to consider certain workers to have reached the retirement age, and at that point to eliminate permanent total benefits, even if they actually were choosing to maybe work on after that in individual cases. Why should we hold differently here?
Well, I think that we have to have consistent jurisprudence, and the way to have consistent jurisprudence is to recognize that Satterley deals with a lifetime undefined benefit, and that benefit has to stop for people who wouldn't be working anyway. They're permanently and totally disabled. I think that's the distinction that Justice Cotter pointed out earlier. Whereas people that want to go back to work or may go back to work, like Mr. Caldwell did and proved for 15 years after his retirement age that he continued to work and he still wants to work and he's staying active and spends 20 hours a week as the president of the Valley County Historical Society. This man stays busy and he intends to stay busy, and there are other people like that. Some of them are on the United States Supreme Court. Some of them are on this court. There are ages that and the real core issue here is when is retraining impractical? We understand that the legislature has a difficult job. That, as Mr. Grossfield pointed out, there's this balancing, trying to get to the right mix. But if there's no reasonable chance of reemployment, the people that are totally disabled, the workers' compensation system isn't intended to be a retirement system, and that's what was held in Satterley. And that fits in fine with people that can't work. People that can work find that if they are processed under Section 1006, the vocational rehabilitation statute, it takes into account all the important factors: ability, education, prior training, work history. You won't get a plan unless you have a vocational plan that's reasonable, and you won't get a plan that doesn't have a reasonable chance of reemployment. Okay, those are all things within the statute, as well as age. Those are all factors that if a person is not going to have a reasonable work life afterwards, the vocational consultant takes that into account.
Well, Counsel, can't the legislature establish some sort of presumption on age to avoid arbitrary decisions by vocational rehabilitation specialists? So some person who's 75 gets them, someone who's 79 doesn't get them. Can't the legislature say, well, here's our presumption and you got to overcome that?
Well, certainly the arbitrary part of this case is to just pick retirement age and have the Social Security system choose who does or doesn't get benefits. So I don't think that the legislature can pick an arbitrary age, and I don't think that we risk the process under 1006 resulting in arbitrary determinations. First, the vocational consultant has to be a certified consultant, so they have training. They're not chosen by the worker, they're chosen by the insurance company. exclusively. In addition to that, the insurer has to approve whatever plan comes up. So there's a second safeguard. They choose the vocational consultant. They have to approve the program themselves, and then the department has to approve it.
Counsel, correct me if I'm wrong. In this case, Mr. Caldwell didn't get to that stage of the process, did he?
Right.
He was denied his benefits before he could even go visit with the vocational rehabilitation.
That's exactly right. That's exactly right.
So we don't have the benefit of that to help us in this process.
We don't have that, no. We don't have that here. But if it got to that point, there are all these safeguards. In addition, it's limited to 104 weeks. In addition, there's a 78-week statute of limitations. If you don't start a plan within 78 weeks of reaching maximum medical improvement, then you don't get your plan. So you have a limited scope of benefits, 104 weeks, and you have to start within a certain amount of time. None of those things are being challenged. Those all fall within the attempt, and what would work fine under 1006 is to not have an arbitrary line. Okay? Now, some of you, my wife and I both got one of these. The Social Security sends these out once or twice a year and explains what our benefits are. Think I'm retiring? This is from the Social Security Administration. Some things to consider. Retirement can have more than one meaning these days. It can mean that you've applied for Social Security retirement benefits, or that you're no longer working. It can mean that you have chosen to receive Social Security while still working, either full or part-time. All these choices are available to you. Your retirement decisions can have very real effects on your ability to maintain a comfortable retirement. Everyone needs to try to find the right balance based on his or her own circumstances. That's what 1006 does, and that is anathema to what 710 does. It allows for the kind of personalized adjustment for what individuals need to remain active and to remain productive in this society. One of the themes that keeps coming up is cost. Now, the insurers know how much it costs them to retrain workers that are under 62 or 65. Why isn't there any evidence on that in this case? There's just a lot of discussion about this balancing of the cost, but they're not submitting evidence on that issue. How much does it cost? Maybe they'll explain that to you. So when an injured worker becomes medically stable, and this didn't happen here, but this is how it would happen. If the injury prevents them earning the same wages they had before, so there's another safeguard. If they can earn the same wages before, they'd never be entitled to vocational rehabilitation. Then they would be entitled to compensation for that wage loss, or retraining, or both, some combination of those. Now, the amount of the wage loss is the single largest factor in determining the amount of compensation that a person gets, or the amount of retraining they would get. The larger the wage loss, the larger the compensation. But the purpose of retraining is to reduce the wage loss and return people to work. Retraining injured workers directly serves the public policy that is stated in Section 105 of the Act. It gets people back into the workforce. The natural consequence of retraining an injured worker is to increase his wage and reduce the amount the insurer pays out for wage loss. So the cost of the training has an inverse relationship to the cost of the wage loss. The determination of how much is going to be paid out for the wage loss comes after the retraining program, so that the insurer gets a repayment for that. And if you'll look at docket number 41 in the record, that's the entire oral argument below. Justice Shea had several questions that the insurers, some they couldn't answer, but they center around the possibility, and actually the likelihood in many cases, that the retraining plan will be a net savings, because your wage loss is reduced. It won't always be. I'm not saying it'll always be a net savings. And it might not even be a net savings in terms of dollars to the entire system. But in many cases, it will be a net savings because the person's wage loss is not as great as it was before. So they're going to pay out less in permanent partial disability benefits, which they're required to pay under RESER. How much will the savings be? How much are they paying for these kind of plans as it is? We haven't heard anything like that. We don't know. They would have the data. They're the ones that bring up the cost issue, urging the court to take into account the cost, but how much will it be? It's undisputed that retraining can ultimately save insurers money in some cases. It's also undisputed that the public policy as stated under Section 105 will be served by getting workers back into the workforce. Judge Say in that same document kind of rewrote Section 105 as it is being read by these insurers. This is on page 24 of docket number 41. The court saying, you're carving out an exception to that stated purpose. When you're saying that, I mean basically what we are reading 105 is now, it would be basically, quote, therefore an objective of the workers' compensation system is to return a worker not eligible for retirement to work as soon as possible after the worker has suffered a work-related injury or disease. The not eligible for retirement was something that the insurers are urging here to change the public policy of Montana. The real question is, how can we rationally say that a person who's 61 can get retraining after this, two workers working side by side, injured in the same way, same work life left. One is 61, the other is 63 or at that retirement age. And one of them doesn't get any benefits, doesn't get retrained because he's 62 or 63. The one who is a little younger, because of this arbitrary cutoff, gets retraining, is back in the workforce, and maybe works until he's 85 or however old Mr. Caldwell will continue if he's retrained and put into a position where he can do that. So I would leave with these questions, and perhaps the insurers will answer these. What is the rational basis that 710 serves when Section 1006 already provides a process that looks at all of the relevant factors? And the other is, how will this court reconcile the precedent of RESER with the result that's urged by the State Fund and Maco in this proceeding? Thank you.
Mr. Grossfield.
I have two. May it please the court again. Some of them are arguing before this court today. And if you adopted a rule that 65-year-olds couldn't argue before the court, now that would be arbitrary, I suggest. But in this particular case, I would refer you to your language in Satterley. And it states here, we have long held that the power of the legislature is to fix amounts, time, and the manner and payment of workers' compensation benefits. The principle coupled with the constitutional role of this court to presume the statute to be constitutional and look to any possible legitimate purpose requires us to conclude that it is with the legislature's legislative prerogative to adopt basically the benefit structure. And I think we have demonstrated here today why the legislature took reasonable steps to terminate rehab benefits. A couple of issues regarding cost. Cost was discussed extensively at the lower court, so it is in the record. And I think the court can take judicial notice of that. For instance, the current benefit rate, weekly benefit rate for one that is a higher level salary is $604 a week. You know, that's about $31,000 a year. And if you put somebody in a 2-year program, that's $64,000 plus tuition, etc. Now, not everybody is going to go through that kind of a process. But even the cost of rehabilitation review initially costs several $1,000s. So it is cost, and cost is one consideration this court can take when reviewing it. But I would suggest to the court it is more an allocation of costs of the workers' compensation system this court should view. And if you're going to extend costs to those that have reached generally what's considered retirement age and give those kind of benefits, you're going to force the removal as a practical matter by the legislature from those that are in a younger age area and those that really need probably an increased cost in income through permanent partial, temporary total, or permanent total benefits.
Counsel, you said that cost is a legitimate consideration. Is it the sole consideration?
It is certainly not the sole consideration, but it is a legitimate consideration.
So doesn't the rehab statute take that into account?
Well, but if you're going to provide rehab to those that have reached Social Security retirement, then you're extending significant costs to those individuals. And you know, in Montana, we have about 30,000 industrial injuries a year, and about 4,000 or 5,000 of those are wage loss type injuries. And so you start adding those over the time, and you have a lot of people that are reaching that age level. And a lot of them are going to demand some type of rehab assistance, or certainly their counsel is.
Thank you, Mr. Grossfield.
Thank you.
Cause number 10-0427, Caldwell versus Workers' Compensation Trust will be submitted. Thank you to counsel. Clerk will call the next case. This is cause number 10-0348, entitled the Kalispell Education Association versus the Board of Trustees, Kalispell High School District. Counsel ready to proceed? Mr. Hindoin.
Mr. Chief Justice, members of the court, may it please the court, my name is Jeff Hindoin. I'm an attorney from Helena, and I serve as legal counsel for the Kalispell School District. The fact background here is, as we've noted, it's pretty straightforward and undisputed. The case was presented to the lower court via cross motions for summary judgment with the Kalispell Education Association initiating a petition to compel the arbitration of a grievance involving Mr. Hartford and the school district. And the school district then responded to that petition to compel arbitration by filing a cross motion and a cross claim or counterclaim for declaratory relief concerning what, from the school district's perspective, are some predicate legal determinations that need to be made before you can reach the ultimate question under the petition to compel, which is whether or not a valid agreement to arbitrate the disputed issue existed between the parties.
Counsel, why shouldn't that initial decision be up to the arbitrator based upon the U.S. Supreme Court's decisions?
In
Maco and others.
Well, because in this instance, we're dealing with a substantive arbitrability dispute, not a procedural one. This case actually has a procedural arbitrability issue in it once you get past, but the fundamental threshold question of whether or not a valid agreement to arbitrate exists between the parties is a question for the judicial branch, and it's been recognized by the Supreme Court, the U.S. Supreme Court, and certainly recognized here. And that's the fundamental core piece of 27-5-115, is that substantive arbitrability issue is for the judicial branch to decide. And the legal issues raised by the school district in its counterclaim for declaratory relief are, in essence, and that's ultimately, I guess, the way this case has to come down, is an issue of analytical sequencing. From the school district's perspective, you can't get to a place where you can conclude as a matter of law that a valid agreement to arbitrate this particular dispute existed without making a legal conclusion
that individual teaching employment contract remained in full force and effect.
Well, counsel, that's the nut of this case, isn't it? You say that it was void as a matter of law. The other side say that the contract itself, by its own language, says it's voidable, and it can only be voided by the Board of Trustees, which they did not do.
Correct.
So the language of your own contract says that it's voidable. Why should we adopt your position and rule that it's void as a matter of law?
Because under, quite frankly, all of the case law precedent that's been brought up in this case, and the district court's conclusion below, to the contrary, to the point you just made, and that's the core conclusion reached by the district court, was that individual teaching contract remained in full force and effect because the Board of Trustees didn't act to void it, because that conclusion and the language in the contract is contrary to the legal principles cited in every one of those legal authorities in the briefing. The underwriter's case, the petroleum tank release case. It's the essence of the distinction between a voidable contract and a contract that's void. Void is a matter of law. And that's the discussion in the Fulton case and goes on through those other cases. And
Counsel, did the district court have to reach that question at all of whether the contract was void or not? Couldn't it have let that issue for arbitration and just made a decision based upon whether this was an issue which arose out of the collective bargaining agreement and decided on that basis?
From the school district's perspective, no, because what we're sitting here talking about right now is the meaning of a statute passed by the Montana legislature. It's the public policy of the state of Montana. We didn't agree to have a contractual arbitrator. We're not talking about the terms and provisions of a contract and what those mean. What we're talking about is the force and effect of the public policy of the state of Montana, which is uniquely the role of this branch of government, not from the school district's perspective, the role that they agreed to have a private contractual arbitrator serve under that collective bargaining
Counsel, you talked about statutes setting forth the terms that guide us in this situation. And I wonder how you reconcile your position with 20-4-202, which said that if a valid certificate is not registered within 60 days after services are begun to perform, that person shall not receive further compensation until he has registered his certificate. It doesn't say that his contract is void. In fact, it appears to presume that his contract remains in force and that he can resuscitate it once his certificate is registered. How do you reconcile that with your position that the contract voided right there when his certificate ran?
Because, I mean, that position is raised by KEA, and I guess from my perspective, it's kind of the consummate red herring, because what that statute talks about is registration, not possession. If Mr. Hartford had had his certificate and had had it just stuffed in his drawer and had not taken it down to the courthouse to register it with the county superintendent, he would have remained a member of the bargaining unit, he would have remained a teacher as defined by Title 20 under the statute, and his individual employment contract would have remained in full force and effect. What that statute talks about is registration, the act of registering the certificate. It says nothing about what if that person doesn't even possess it. I mean, you can have an individual who doesn't register. They don't get paid under that statute, but if they have the certificate, then their contract's in force and effect. They're part of a bargaining unit as defined by this.
So if they have a certificate that has expired, their contract is not void? Is that what you're saying?
I'm saying if that person has the certificate, it's a valid one, they just haven't registered it. That's my point about that statute, is it talks about the ministerial task of taking your valid teacher registration down to the county superintendent of schools and registering it. What we're talking about here is someone who not only didn't register it, they didn't have one to register in the first place. And that statute doesn't speak to the force and effect of the absence of even having the registration in the first place. That absence, the total absence of a valid registration, is addressed by the other statutes we've talked about.
Well, Counsel, what's the effect of the fact that the certificate was reinstated and was retroactive?
My only response to that, Your Honor, is that for whatever reasons, I guess, and not in the pejorative sense, but for whatever reasons of bureaucratic convenience OPI may have for not wanting certificates out there with anything other than a July date on them, July this year, July next year, it doesn't alter the reality that the school district or any other school district would be confronting at that point in time when that individual undeniably doesn't have a license. They're standing in front of students, they're in that classroom, and they don't possess the licensure required by the state of Montana to be filling that position. And in this case, you know, it happens
but when
that...
you reinstate a license, it relates back to the day that it expired, does it not?
That's my point. I guess it's administratively, but it doesn't again change the fact, because when they were there and actually doing it, and ultimately when school districts are making decisions in real time, they don't know that. They don't know if that teacher's going to come back in 2 weeks, 4 weeks, 8 weeks, 4 months, or never with a certificate that may then be retroactively effective to the year back when they started. And that's, you know, the reality that school districts confront when they're trying to deal with it.
Why does it even matter whether the school district knows that or not? I mean, who cares? They kept this teacher working, even though they decided that he couldn't be paid according to a certified teacher. They continued to employ the teacher. He worked as a substitute teacher.
Exactly. Worked in a capacity that the law allowed the school district to employ him in. Absent that certificate, it's illegal to employ him as a teacher, a certified teacher, to put him in a classroom. And in fact, the accreditation standards don't allow you to have non-certified staff in the classroom past the 25, 30 day, I can't remember the specific number.
Well, if we adopt your position here, why didn't the school district, once they knew that this teacher didn't have a certificate, why didn't they terminate? Why didn't they say, you're done, you can come back and ask us to employ you as a substitute teacher, but your contract is void, and put that in writing? Why didn't they do that?
I think they did, effectively. We didn't put it in writing, I guess. I mean, unless until after the dispute arose. But from that perspective, as of the point in time these decisions were being made, his status under the law was that of an unlicensed individual, and no different than any other substitute teacher who they come and go without action of the Board of Trustees in school districts all across the state.
Counsel, it's my understanding that in the Buckeye check cashing case, the Supreme Court, in discussing whether a situation was subject to arbitration, said that there's really no distinction between a contract that is claimed to be void as opposed to one that is claimed to be voidable when determining whether arbitration should proceed.
I think, Your Honor, that Buckeye check cashing is considerably far afield from the issue in this case, in the sense that what Buckeye involved was the question of whether or not a challenge to an agreement as a whole, as opposed to just that subset of an agreement that required arbitration, was a challenge that had to be raised before an arbitrator versus raised before the judicial branch as a substantive arbitrability thing. And the Buckeye court basically said, and there were implications in involvement of Florida law in that case as well, but that if all you're doing is challenging the existence of the agreement as a whole, that has to go to the arbitrator. And if you're challenging just the existence of the arbitration provision or the viability of that, then that is the substantive question that is appropriately put before the judicial branch. And in this case, again, we're talking about getting to a place where you get to the requisite level of focus on what the disputed issue is and whether or not an agreement exists to submit this to arbitration. And analytically, from the district's perspective, one, you have this issue of not having a contract in place, a written contract. And it's important because MEMFT has noted that as well, that it's the bridge. It's the bridge in time between when Mr. Hartford services as a non-certified substitute teacher ended and that point in time when he walked back in the door with a valid certificate and a grievance form in his hand.
Counsel, let's look at the end game for a minute. You're saying that this dispute should not go to arbitration. What then is Mr. Hartford's remedy? Does he get to bring a direct action?
No.
So he doesn't have a remedy?
No. Not that you could identify. And again, for the reasons noted in the briefing. I mean, if you go back to the point in time when all of this occurred, and that's one, you have to work through these analytical steps to get to a platform where you can make the decision. Was there an agreement to arbitrate this dispute or not? One, the written contract is void, not voidable. And to answer Justice Wheat's question, I'd urge you to look at those authorities, because the answer to that is just because the parties put that in their contract, if it's contrary to statute, it can't be enforced.
Well, I understand this is the school district's contract.
It is.
That they require the teachers to sign. So
it is.
It's their contract and they drafted it. And they put the language in it. And they put the language in here that says that this contract is voidable at the option of the district. It doesn't say it's void if you don't have certification. It says when you don't have certification, the contract is voidable at the option of the district. That's their language.
It is. And my rejoinder to that is the legislature's language is you can't have a contract with an individual to serve as a teacher who doesn't have a license. So the Kalispell School District doesn't have the authority, the discretion to say, you know what, we can overlook that. That's the essence of the distinction between void and voidable, is that the parties can't agree to make something a contract that's contrary to the public policy of the state of Montana. And that's the essence of the tank release case when Federated had a notice provision in its insurance policy. They put it in there, but it's void as a matter of law because it's contrary to public policy. And just in wrapping up as far as the analytical steps there, one is being the absence of the written agreement, because from our perspective, if the written agreement doesn't exist, if it's truly void, there's no linkage there between that point in time when Mr. Hartford's no longer employed and when he returns with a certificate. The second piece is his membership in the bargaining unit, that core front-end question. That's the question and the analysis that's laid out in that Huron case that's cited in the reply brief. And so ultimately, I guess from the school district's perspective, we're talking about not being able to get to a place where you can conclude that there's an agreement to arbitrate. We agree to arbitrate disputes with the KEA about issues arising under that collective bargaining agreement. We have a valid CBA, we have a valid arbitration agreement. The question is drilling down to the appropriate level of analytical granularity to talk about what is this dispute? And it's a dispute over a severance of an employment relationship that occurred when he undisputedly didn't have a license under a collective bargaining agreement that defined his membership by holding a license and employed under a contract that required him to have a license.
Thank you, Mr. Hindoin. Mr. Englund.
May it please the Court, Carl Englund on behalf of the Kalispell Education Association, William Hartford, and MEA-MFT. Context matters. This case comes to you on an appeal of a grant of a motion to compel arbitration under the Montana's version of the Uniform Arbitration Act, Montana's Collective Bargaining for Public Employees Act, and rules that you have developed in this court in the multiple times that you've looked at this issue, which are based upon the rules developed by the federal courts.
Well, Mr. Englund, let's deal with this issue about voidability and void as a matter of law, because I think that's what counsel is talking about, is when you drill down through the layers, that really is whether you're going to arbitrate or not, is whether you have a valid contract or not that you can even file a grievance on, is the way I understand the dispute here. So
the rules are that you look first to the existence of a collective bargaining agreement to determine whether or not the parties have agreed to arbitrate. Here we have a collective bargaining agreement. The collective bargaining agreement has a grievance and arbitration procedure in it. If the collective bargaining agreement...
Well, let me interrupt just for a second. So are you saying then that even if the contract is void, that doesn't matter?
I'm saying if the contract is... First of all, that question belongs at the arbitrator. The question, if you have a collective bargaining agreement with a provision for arbitration, then you have a presumption of arbitrability in the sense that in order to arbitrate the kind of dispute that you're looking at, and this kind of dispute is an allegation that he was discharged without cause, that an order to arbitrate that kind of dispute should not be denied unless it can be said with positive assurance that the arbitration clause of the collective bargaining agreement is not susceptible to an interpretation that covers that kind of dispute.
Counsel, how would you respond to Mr. Hindoin's claim that because Hartford did not have a valid certificate, he was not a member of the bargaining unit and therefore not protected by the provisions of the CBA?
Well, the first thing I would say is that you look at the collective bargaining agreement and you will see that nothing in that agreement excludes from the arbitrator that predicate question of whether or not this particular grievance was certified at an appropriate time in order to have access to the grievance procedure. In other words, if you put it in the terms of the proper analytical framework, there is not a specific provision of the collective bargaining agreement or the more forceful evidence of the party's intent to exclude from the arbitrator any legitimate dispute about whether the grievance was or was not covered by the agreement at an appropriate time in order to make this claim.
So that's a decision for the arbitrator to make?
That's, first of all, a decision for the arbitrator to make. Secondly, when you get into this question of void and voidable, you have to look carefully at the individual contract. Contracts, first of all, the restatement's contract says there isn't such a thing as a void contract. A void contract is a contract that doesn't exist. Certain kinds of contracts we consider void because they are illegal or the lack of capacity, etc. Okay? But there's nothing illegal or prohibited in that individual contract. He was contracted to teach, which was a perfectly legal enterprise. At the time that he was contracted to teach, he was fully certified, and he was contracted to teach on the condition that he was certified to do so, which is a perfectly legal and proper condition. So this is unlike, for example, the portable embryonics case that we cite in the brief where non-veterinarians were hired to perform non-surgical bovine embryo transfers when the statute says that only veterinarians could do that. And it's unlike the McMinnis versus Fulton case that they cite, where a non-licensed broker was hired to broker stock. Mr. Hartford was contracted to teach if he had a certificate. And the contract went forward, or went beyond that, and said, and you know what, if you don't have a certificate, any relationship that you have with us can be over if we decide to void the contract.
Counsel?
And that's a decision that only the trustees could make.
So are you saying then that when the school district found out that his certification had expired, and so he was out of compliance with his contract, if the trustees of the school district had sent him a letter saying, under our contract, you are supposed to have this certification, and it allows us to terminate this contract, consider it void at our discretion if you don't have that. If they had done that and done that in writing, we wouldn't be here because there wouldn't be anything to arbitrate.
Yes, there is. Yes, that's the essence of my point. There's a question as to whether or not maybe they had to go through the whole procedures, in other words, have the superintendent write make the recommendation to them, etc. But if the trustees had gone through a proper procedure while he was not certified and said, under your contract, we have the right to void it, we are electing to do that, then we wouldn't be here. While he was not certified, the district had the option not to let him work. While he was not certified, the district had the option to hire him as a substitute because you don't need a certification to be a substitute. While he was not certified, he did not have a legitimate claim to work for the district as a certified teacher, which makes this case unlike the unpublished Michigan appellate court case that they cite in their reply brief. But once he became certified, that contract came back into play. Once he became certified, he was, under the contract, eligible to teach, certified to teach, under a contract that was still in existence. He should have been taught. He should, allowed to be taught.
So once he came back into compliance, then the contract was in full force and effect.
Right.
Okay. And whether the school district hired him as a substitute teacher is really irrelevant to our analysis here.
Right. The only thing that is, the only point there is that the only notice, the only action that was taken under his individual contract is that a principal, not the superintendent and certainly not the school board, came to him at one point and said, well, we don't think we need you anymore.
Okay. Thank you.
But where we get back to is that the presumption of arbitrability is that if the dispute is covered by the collective bargaining agreement, then it must be arbitrated unless the collective bargaining agreement, number one, has a provision in it that says this type of dispute is not covered. And that's the Winchester versus Mountain Line case where the collective bargaining agreement said we don't cover, you can't cover in a grievance matters that are unfair labor practices. Or the second class of cases are taken out are cases that have no basis whatsoever in the collective bargaining agreement, and that's the Klein case, where you said that her individual tort claim for deceit and for the resultant emotional distress damages was not in any way related to the collective bargaining agreement. And it's only those types of cases that are taken out of the arbitration provision. This case is an allegation by somebody who was certified when he signed it, who was covered under the collective bargaining agreement in the first of its 2 years, who was certified when he signed his individual contract, and who was certified when he filed the grievance that he had been discharged without just cause. That is the type of case that is clearly covered by the collective bargaining agreement, and it needed to be arbitrated. That's all the district court said.
Well, counsel, then let me ask, given this approach you've outlined about arbitrability and the presumption, should the district court then have gone ahead and made an affirmative declaration that this contract, this teacher's contract at issue, remained in full force and effect? Wasn't that a substantive issue that was beyond the arbitrability issue?
Well, it's an issue that the district raised in their response to the motion to compel and essentially in their declaratory judgment action. And I don't think the court needed to go that far.
That's an issue for the arbitrator, is it not then, after you determine that it goes to arbitration?
It should have been, but they raised it, and now we have a decision by the district court. I don't know what happens if this case does go to arbitration, what binding effect that might have. But I don't think, Justice Rice, I don't think the district court needed to go that far. Yeah. And that's the point we've made. We made at the district court, and we made in our brief here, where we said, look, you just look at the collective bargaining agreement, look if this kind of case is subject to arbitration under the collective bargaining agreement, look to determine whether or not there's any exclusions. If not, all other questions are what they call, quote unquote, procedural questions and belong in the province of the arbitrator.
Thank you.
And that is as good a summary as I'm going to have, so I will sit down and relinquish the rest of my time. Thank you very much.
Thank you, Mr. Englund. Mr. Hendoy.
Mr. Chief Justice, may it please the court. I guess I only have a few quick follow-up points. What we don't get an answer to, and it's the essence of this whole situation, is
What was that thing when he didn't have a license? The school district had all kinds of options. Well, it's either a contract or it's not, would be my submission. I mean, it's either something that defines a relationship and binds the two parties, or it doesn't. And at that point in time, when Mr. Hartford doesn't have a license to teach, what then is that contract? The statute prohibits us from going out and entering into that as a first step. Plainly prohibits us from that. In fact, it prohibits us from employing an unlicensed individual to teach. But yet it hangs out there in limbo until some point in time when just, as the facts of this case turn out, Mr. Hartford goes and gets a license and goes back.
But it need not have been in limbo, because as Mr. England pointed out in response to a question, had the district, through the Board of Trustees, said the contract is over, we wouldn't be here. So the limbo falls back on the Board of Trustees, doesn't it, instead of on Mr. Hartford? Only if you can look at that contract and come down and say that it's just because the contract says it's voidable means it's voidable. That unless and until the district takes affirmative action to do away with its existence, it remains in full force and effect.
Well, Counsel, isn't a normal situation where a contract is void, Mr. England raised, the activity contemplated is illegal, the party to the contract is clearly not qualified like the veterinarians. Here we have a situation of a contract, we have a certified teacher whose certification lapses, they get reinstated retroactively. It seems like this is muddled enough that an arbitrator ought to sort it out rather than making a decision as a matter of law. How can I cut through all that and say this is void as a matter of law?
Because the one clear thing we've never gotten an answer to is that somehow that temporal shift makes a difference. And from the school district's perspective, it doesn't. I mean, that contract, again, it has to be something at any given point in time. And just because it was valid when it was entered into doesn't mean it's going to remain valid if they lose their licensure. I mean, if, for example, the veterinarians in that case.
What about if a contract for teachers has a morals clause? And a teacher's accused of a crime, is that contract void immediately upon conviction, or would it have to be voided by the action of the? No,
that contract would, because again, I mean, but then you're getting into the focus of this case. In that circumstance, that teacher's contract, you have to go through certain procedures that are required by statute and/or Constitution to terminate it. But they're required by statute and Constitution because that person's status is defined by statute as someone who holds that certificate. They're not someone who doesn't hold the certificate. And so that's how that sequence plays out. The other piece, I guess, to respond to Mr. England, at the end of the day, the school district's perspective is that when you drill down, when you keep moving down to really what is the controversy here, it's a controversy and a grievance that's being brought back in by an individual who, at the point in time the events giving rise to the grievance occurred, didn't have a license, and is trying to assert it under a bargaining agreement that requires a valid license to be in that unit. And from the school district's perspective, didn't have a written individual contract relationship in place. And you can't get to that. You can't just look at the contract and say, you got a CBA, you've got a valid grievance procedure in it, and we're talking about a teacher who says he was terminated for just cause. Those first steps matter. And from the school district's perspective, those are legal determinations to be made in that analysis of substantive arbitrability that has to occur under 27-5-115. And from that perspective, as I think you've noted, I think the school district is at this point stuck with that district court ruling in terms of what the effect of the contract is. But for the reasons noted in the briefing and my argument, I respectfully request that the court reverse the decision of the district court, vacate it, remand it with directions to enter judgment as a matter of law in the district. Thank you.
Thank you, Mr. Hindoin. Cause number 10-0348 is now submitted.